Now, what we are trying to say is there are various other legal formalities to conduct a general meeting. Whether EGM, whenever we are talking about the word meeting, we are talking about both AGM and EGM. Simple. Now, quorum means the minimum number of members which must be present in the meeting to conduct the meeting validly. See, one member, two members can't conduct a meeting. A single member can't conduct a meeting. What will be the minimum number of members to be there present in person to conduct a meeting? So unless an articles provide for a larger number, the very first point is every company may define the quorum in its articles. So, and even that, even in the articles, you can define the limits beyond or in above or excess of these points, which is given in the subsequent one, not less than that. You can define a higher limit. If you have defined the higher limit, that is okay. If you have not defined any limit, the lawmaker says that in a public company, the quorum will be if the number of members are up to 1,000. If your total number of shareholders are 1,000, then at least 5 members personally present. What do you mean by personally present? Proxies are not allowed. Personally present, that the member himself will be present. How many members? 5 members shall be personally present. If your number of members are up to 1,000. If your number of members are above 1,000 till 5,000, at least 15 members personally present will be there. No proxies are allowed. If your members are above 5,000, at least 30 members shall be personally present to conduct a proper quorum. And in all the 3 points or 4 points, the word personally present have been defined. That means proxies are not allowed in the quorum. Simple. At least 5 or 15 or 30 actual shareholders shall be there in the meeting. And in case of a private company, 2 members are there. So in private company, 2 members, and in public company, 5 members up to 1,000 members, 15 members up to 1,000 to 5,000 members, and 30 members above 5,000 members shall be required to conduct a proper quorum. Any number present less than these threshold limits, then the meeting will be adjourned because the quorum is not present. Simple. See, what I'm trying to say is defined under the subsection 2. Now, up to what time we will be waiting? Say, for example, the meeting was scheduled till 6 at 6 p.m. So, till what time we will wait for the quorum? We will not be waiting for hours and hours to quorum for the quorum to be there. The lawmaker says wait for the quorum till half an hour. So the quorum will be judged within first half hour. So if the quorum is not present within half hour, then the meeting is adjourned. But there is a condition. See, the meeting shall be adjourned till the next week, same day, same time, same place. Say, for example, if we were conducting a meeting on this Sunday at 5 p.m. and the quorum is not present, so automatically our meeting shall stand adjourned on next Sunday, 5 p.m., same time, same place. Of course, if the board of directors may define the time or date at any other day, they may specifically define. And if the board is silent, then it is deemed that on next week, same time, same place, we will be meeting and the adjourned meeting. But this is clause A, where the meeting was actually called by the board of directors themselves, and the members were not there. The meeting will be adjourned. But when we had talked about EGM, subsection 2, the members themselves have called the EGM on their own requisition under subsection 2 of section 100. So firstly, they called the meeting themselves by issuing certain notices and all that stuff. And then the quorum itself is not present. This is not acceptable. If the meeting was called by the requisitionist under section 100 and they themselves were not present, then this meeting will not be adjourned, not be postponed. The meeting shall stand cancelled. One thing more, there are two words. The first word is cancelled. Cancelled means altogether cancelled. We will not be conducting it at a later stage. So if the meeting is called by the directors and the quorum is not present, we will adjourn it. If the meeting is called by the requisitionists themselves and the quorum is not present, the board will not accept the same. The meeting will not be adjourned. It will be cancelled. One thing. Second thing, what we are talking about, there are three words basically. First is postponement. Second is adjournment, and third is the word cancelled. Postponement means you called a meeting on Sunday 6 p.m. That means the meeting is scheduled on Sunday 6 p.m. The postponement of the meeting is at any time before the conducting of meeting. That means till Sunday, till 5 p.m. 5 p.m. 5:55 p.m. If we postpone the meeting, that we are not going to conduct a meeting which is scheduled at 6 p.m. So before the starting of the meeting, if we postpone the meeting, that is known as postponement. Once the meeting is started, and then due to lack of quorum or due to any other reason, if the meeting is postponed, that is not known as postponement in the law. That is known as adjournment. So there is a difference between the word postponement and adjournment. Postponement is at any point of time before the commencement of meeting. Adjournment means the meeting is actually conducted, the meeting is actually commenced, and at after you have commenced your meeting, you had counted the quorum is not present. Now what we can do is we can adjourn the meeting. And cancellation means altogether we had cancelled, we are not conducting the meeting. Simple. If at adjourned meeting, if in case of adjourned meeting or of a change of date, time, place, the company shall give at least 3 days notice. Now, for the adjourned meeting also, the company will call everybody. The company will give members to notice. Either individually, you serve individual notice at the registered office by registered post, hard copy letters, or if you believe that there is not much time that all the members across India can receive your individual letters, then you can publish two newspaper advertisements, one English and one local language of your state. And you can at least 3 days before the meeting, that the adjourned meeting has been called, and for that adjourned meeting we are talking about the notice of the adjourned meeting, either 7 days, or sorry, either 3 days notice, or if the individual notice is not feasible for the company, two newspaper advertisements are sufficient to call the adjourned meeting. These are known as adjourned meeting notices. And if the adjourned meeting also, the quorum is not present. See, if the meeting was called by the requisitionist and the quorum is not present, the meeting is cancelled. But if the meeting was called by the board, it was first adjourned. Say, for example, in the first meeting called by the board, the quorum was not present. The meeting is adjourned to the next week. Now, in the adjourned meeting also, if the quorum is not present, then the meeting will not be further adjourned. The members present there, be it one member, be it two members, no matter what, shall be deemed to be the quorum, and the meeting will be conducted. We are not going to postpone and adjourn the meeting due to lack of quorum. We will only adjourn the meeting due to lack of quorum only once. And that to the meeting which was called by the board. If the meeting was called by the requisitionists and the quorum was not there, in the first meeting itself, the meeting will be cancelled. Simple. So the clause number 3, subsection number 3 is for which meeting? The adjourned meeting called by the board of directors. That is, this is related to subsection 2, clause A. Subsection 3 is related to 2A and not 2B, because 2B meeting can never be adjourned anymore. It will be cancelled. Is it clear?